Welcome everybody to the show. Hi everybody. We are preparing our pro se defense against charges of disorderly conduct while acting as press on a stringer assignment we got about a month or two ago, and we were going over all the ways that we were excited about having our day in court. And you guys may not know, but in the state of Colorado, if the municipality is not seeking jail time, then they don't afford you an attorney.
They don't.
So we intend to file 1983 claims for damages for what happened to us and having our rights taken away and deprivation of rights and all that on this assignment. But we can't plead out, we can't plead guilty or anything like that. We don't have any representation, and so we're left with trying to figure this out using conversational AI and our own two brains. So you guys are lucky enough to be here with us today. If we have please drop the cash tag, and if anybody wants to help with some legal stuff that we got going on, I'm in a custody battle right now. I need representation. Feel free to drop something in there, say custody in the memo line. Otherwise, here we go. Thank you all for being here. So, the charges in this case are, what's your charges?
Well, it looks like obstructing interference and
Disorderly conduct.
disturbing the peace.
Oh, disturbing the peace, guys, and obstruction. So that's the charges that we received in Aurora, Colorado.
This doesn't say, okay, no, that's not injury to property. So say, I didn't injure anybody's property.
It looks like obstructing and disturbing the peace are the two charges. Obstructing being 94-378 section number, and disturbing the peace is 94-102. Okay, these are misdemeanor crimes. The city is not seeking jail time at this time. We are working on an example of a motion to dismiss the case based off of, how's the audio, everyone? I want you to be able to hear this when it starts speaking, okay? Let me get you down here closer to the computer, turn the volume up and everything. And this is an example of the motion to dismiss that I might change and use, okay? Take off some of my personal information there. Nobody wants to hear my phone number. And if they do, probably can't have it.
In the Aurora Municipal Court, City of Aurora, Colorado, the people of the state of Colorado, plaintiff versus Jamie E. Bates, defendant, case number 2452,508, summons number J300032, motion to dismiss, comes now Jamie E. Bates, defendant, pro se.
Okay, I'll just read it.
Respectfully moves this court to dismiss the charges of disorderly conduct brought against him.
I'll just read it. I'm probably louder voice for everybody to hear. How's the audio, everyone? Will you check the chat? Are we 5 by 5 in there? Okay. Did you hear the computer when it was reading? Anyways, comes now the defendant in this motion, case number, summons number, motion to dismiss. When you're doing your paperwork, guys, you want to make sure that you follow the formatting for motions in your jurisdiction. So I'm pretty sure out here in Aurora, Colorado, the motions have to be all unbold and 12-point type. That's what I've been using when I'm doing my documents inside of Google Documents. So here's the motion over here I'm working on inside of Google Documents. Okay, and so I'll go ahead and read it out loud to everybody. You can hear what we're kind of thinking of here. Comes now Jamie Bates, defendant, pro se, and respectfully moves this court to dismiss the charges of disorderly conduct. And what did you say the other one was? And my memory is obstruction.
Yeah, obstruction. Well, it was obstruction and disturbing the peace.
Okay, so disturbing the peace and obstructing. Let's make sure we have that all right.
Yeah. Disturbing the peace.
Well, you know what, another thing I was thinking is that we need to learn about discovery. So when you're submitting documents and evidence, especially for your case, or maybe you are calling witnesses on your case, that'll be part of a thing called discovery. And you need to make sure you're up on your municipality's rules about discovery where you are. And that way, there may be deadlines and stuff. There certainly is deadlines, and you need to make sure you get your witness list and all of that in. And then we started talking about how cool that would be, since we're using Irizarry versus Yahia defense for our main defense here in this case. Wouldn't that be cool if we could get Irizarry to come in here and maybe co-counsel with us or something during our trial, or speak as an expert witness on the case? After all, he did make case law, so.
He absolutely did, and that would just be so fantablazing.
Fantablazing. And I wonder, did Liberty Freak do that pro se, or did he have an attorney? Because we're doing this all pro se here, fellas. Wouldn't that be neat though? Chime in, Liberty Freak. Everybody tag in Liberty Freak if you can. Get him in this chat. Also, we're gonna summons one another. So if you have witnesses, you need to summons those people. You need to provide a witness list and then give that over to the prosecution, okay? That's some of the things we're working on today. We're also gonna motion to have media inside, such as independent journalists like Mexican Longhair or other independent journalists that are in the area, as long as they've been nice to me. And no, I'm just kidding. Whoever wants to come, cut the plastic. We're gonna put down some of these names and see if we can even get them to come in as professional witnesses. And so that's where we at on this right now, guys. Let me read this. In support thereof, the defendant states as follow. Factual background, number 1. On March 17th, 2024, the defendant was lawfully present at the scene of a reported homicide in Aurora, Colorado. While exercising their First Amendment rights as a journalist or member of the public, the defendant interacted with officers of the Aurora Police Department investigating the incident. This interaction involved the defendant verbally protesting and questioning the officer's instructions regarding restrictions placed on being near the crime scene. So we were just questioning them, guys, about the yellow tape. How come the yellow tape's up? We've been doing yellow tape audits lately, haven't we? If we get to the crime scene and it seems like they've been headlong into this and they're not currently chasing some suspect, or not suspect, trying to kidnap some member of the public, then we will say, hey, where's the yellow tape? You guys doing an investigation, or is this an open sidewalk, man? I'm gonna record right here, you know? And so it makes them put up the yellow tape. In this particular case, if you were watching the live stream, feel free to go back and watch the live stream in Aurora. In this particular case, we received charges. So,
yes.
That being said, here we go. Number 2, the charges violate the First Amendment. The charges of disorderly conduct, no, it wasn't disorderly conduct though, it was obstruction. Obstructing, and what was the other one again? Give this to me, okay. Probably ask about 10 more times. Obstructing and disturbing the peace. So I think a member of the public did come out.
Redressing, because one of the officers actually said something along the lines, imagine that he had already put the yellow tape
Yeah,
out.
man, how insulting. He said, imagine yellow tape.
Yeah, and
imagine it.
Yes, and I said, I am not going to imagine you stepping on my rights.
And I told him, I'm not going to imagine you doing your job.
That's
and immediately, so you want to talk about effective activism.
Yeah.
Immediately, somebody started putting, another officer, we later talked to, I can't remember his name offhand, but I got his name. Another officer started putting up the tape immediately, right?
Mm-hmm.
And ultimately, we were given a chance, or whatever they say, to behave or whatever, and we ended up getting arrested. So you guys feel free to go back and check out that live stream and tell us what you think in the comments.
I contend a redressing happened.
Yes. Well, you guys go back, look at the video after this, and then tell us in the comments, okay?
Yeah.
Number 2, the charges violate the First Amendment. The charges of obstructing and disturbing the peace violate the defendant's First Amendment rights to freedom of speech, freedom of the press, and freedom to assembly. Freedom of press. As a journalist, the defendant has a well-established right to gather news, including observing and recording police activity in public spaces. The defendant's actions are at the scene fall squarely within this right. Freedom of speech. The First Amendment protects the right to express opinions and question government officials, including police officers. The defendant's verbal protest questioning the officer's instructions constituted protected speech. The First Amendment protects the right of peaceably assemble in public. The defendant's presence at the scene, even if near a crime scene, is protected by this right. Number 3, the charges lack sufficient evidence. Even if the court finds the defendant's actions were not protected by the First Amendment, the charges lack sufficient evidence. Legal standard. The city must prove beyond a reasonable doubt the defendant's conduct intentionally or recklessly caused alarm or inconvenience, engaged in fighting behavior, and or obstructed the police. So obstruction is a physical act. We never partook in any physical acts, guys. The tape was already up and we were on the other side of it when we were arrested.
That is correct.
Mere verbal protests or disagreements with police officers, even if heated, do not rise to the level of disorderly conduct. Insufficiency of evidence. The available discovery materials, including police reports and body cam footage, failed to demonstrate the defendant's actions constituted disorderly, or I keep saying disorderly conduct. Let me fix that right now, everyone. That was originally what I had in here, but we're gonna put it like, right, obstruction and disturbing the peace. The available discovery materials, I said that, failed to demonstrate the defendant's actions constituted such crimes. Conclusions. The foregoing, okay, so before we get to the conclusion here, I actually had several things I was talking to generative AI about, and we will just go over them real quick. So in this case, I want my two primary and 2 secondary reasons are usually a good case. So you want to have 2 primary and 2 secondary, ideally, reasons why you're seeking what you're seeking. If you're going to put legal paperwork in, if you have all 4 or more, you're doing really good for building a case, for having your motion granted, okay? So we're gonna use primary defense, Irizarry versus Yahia. Well, the primary defense is, yes, Irizarry versus Yahia. As I understand, that case law here in Colorado has been decided that the First Amendment rights have been protected. The rights of journalists are protected in Colorado. And police don't have qualified immunity, so they really tend to give us our own space. Not in this case, though. So that will be our primary defense. Secondary defense is actually going to be, I believe this is a United States. It might be just a Texas thing. What's Houston v. Hill? Is that the city of Houston?
I believe so.
Well, we're gonna need something in the United States code that, so you always wanna back up your state case law with federal case law that shows. So you're going down the line. You show the Constitution upholds your actions. Then you show federal case law that upholds your actions. So can somebody look for that federal case law for us? I'm gonna do a little search. Then you wanna have state case law that upholds your actions. You know what I mean? And anything else that can uphold your actions. We need to find a U.S. case law.
This is for Aurora, for an Aurora case. We've got Mike Stevens in the house, and we also have Leslie Sullivan.
Federal case law.
Hey. Car Thief News is also in the house. Thank you for coming aboard.
So I'm gonna do a little DuckDuckGo search of federal case law supporting First Amendment press rights. Motion to dismiss. See what comes up. Smith versus Wright. No. Well, I didn't find something on the first page of DuckDuckGo, so I'm gonna use my generative AI, my conversational AI, and I'm gonna ask it about that. It will go search the internet for me. Just gonna ask it to search the internet for United States case law supporting First Amendment press rights, motion to dismiss. And it'll go through and here it goes. So we were gonna do Irizarry versus Uhia. We were gonna do Houston v. Hill, City of Houston versus Hill, as a lesser. That would be one of our first lesser supporting things because it's from another state. It may not necessarily apply, but if you could put it together and mesh it in with other federal and local case laws and stuff, it'll just show that there is precedent for protecting these press rights versus the police being able to call disorderly conduct.
Smith v. Cummings also, I think.
Well, let's use that as another lesser, okay?
One, yes.
Smith v. Cummins, Georgia?
Yes.
Okay.
That would be fabulous, Leslie. Yes. Lady Justice Liberty Press. Yeah.
She got something for us?
Yes, she does. She's got some case law. That would be so fabulous.
We need that United States federal case law, if possible.
Hey, 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 we got Nick in the house. Fabulous having you aboard.
Thank you for being here, Nick. And did you get,
I'm gonna come over and see.
Hubenstein-Weber's discussion. See Florida case law in Whosin and Weber's discussion on First Amendment defenses. That's interesting. This principle underscores the robust protection afforded to speech, even in confrontational or disruptive contexts. When preparing your motion, these principles can be vital in arguing that each, for detailed examples and further reading on similar cases and defenses, you might find resources and case analysis at the Knight First Amendment Institute and detailed arguments related to specific First Amendment cases on Whosin and Weber's legal website. I have never heard of either one of these guys. I'm gonna bookmark them right now.
Yes.
And you guys should check those out. Knight First Amendment Institute and Whosin and Weber's legal website. So they have specific First Amendment defense cases on there, okay? I'm gonna ask it to search those sites now. Please search those sites and the internet to provide me the specific United States federal case law precedent relevant to this Aurora case.
Leslie, thank you, Leslie Sullivan, for sending in some
Nice,
case laws for us.
amazing. Thank you, Leslie Sullivan, very much.
Yeah, thank you.
Look, New York Times Company versus Sullivan, 1964. You heard about that one, Leslie? It's got your name, isn't it? Leslie Sullivan? Huh? This seminal case established the actual malice standard, which is crucial for defamation cases involving public officials. Oh, okay. Hey, that one might be useful for some of our buddies out there. Anyways, check that out. New York Times Company versus Sullivan, 1964. The seminal case established the actual malice standard, which is crucial for defamation cases involving public officials. The Supreme Court ruled that the freedom of speech protected by the First Amendment can extend to erroneous statements about public figures, provided they are not made with actual malice. This case is often used to underline the robust protections afforded to the press, especially when the speech concerns public figures or matters of public concern. Hustler Magazine Incorporated versus Falwell, 1988. The Supreme Court held that speech guarantee prohibits a public figure from recovering damages for emotional distress caused by the publication of a caricature, parody, or satire of the public figure that a reasonable person would not have interpreted as factual. This underscores the, I don't know where the whole screen just went. What is this? Did you read it?
Well, yeah, here's a US v. Brown, 2003.
Brown's mere presence in the parking lot late at night, several hours after a shooting, does not meet the standard of articulable suspicion. This may be, maybe we could search for First Amendment or something in here.
Okay.
Maybe shoot this over to me in Messenger or something. The whole screen disappeared here. I don't know why I did that again. Anyways, so we can do the Smith v. Cummings, Georgia. We can use these ones incorporated in our incorporate these into a motion to dismiss, including two primary reasons. Number one, Irizarry v. Yahia.
We got fabulous having you aboard.
Hey, No Name Color, thanks for showing up, man. What's up, dude? Good to see you. We're just doing a little pro se study in here. It's like I'm in the wrong conversation here all of a sudden. Hold on. Let me go back. I thought it's trying to talk about my custody case for some reason right now. Embarrassing. Come on now, you're making yourself look bad here.
Well, while you're typing that up, I want to tell everybody about thepolicerecord.com. Have you identified a cop today? You should. Get on over to thepolicerecord.com and you can identify a cop, put their information in there with their badge number and a picture, and some details about your interaction. Thank you, No Name Coder.
Thank you, No Name Coder. What the heck?
What's going on?
Oh man, I don't know. It just interrupted my. It's acting really goofy actually. I don't know what it's doing. It's really acting weird, honestly. I've had to regenerate it a couple of times. I don't. Oh, I'm sorry. Was that your foot?
Yeah, it's all good.
Okay. Anyways, guys, we're working on these pro se cases. We're so glad to have you in here. If you could provide any advice or anything, you can come up with some case law that would help us. That would be super duper.
Absolutely. The thing is, we was on a bona fide lead, fresh, hot off the wire from Stringer.
Yeah.
So when all this happened, so we've got evidence of that even.
Abe Irizarry, a YouTube journalist who was filming a DUI traffic stop in Colorado when Officer Yahia obstructed and interfered with his filming. The district court recognized that filming police in public is protected under the First Amendment, subject to reasonable restrictions. However, why does the screen keep going out on me like that? I just don't understand why it just keeps doing that to me like that. So I'm just gonna have to reload it again and again and again. I've had some pretty bad luck today, guys.
Yeah.
I was filed a bunch of paperwork in my custody case. They went ahead and had the hearing without me.
Yeah.
I filed a bunch of paperwork, but I didn't have any legal representation, and I couldn't be in Mississippi. I can't go live in Mississippi. The Chancery Court, where the proceedings are happening, they don't have any ability to do virtual court proceedings, I guess. So ultimately, my request for special accommodations, virtual appearance, never even was heard. They didn't ever read it, I guess. So they didn't have me in the courtroom today while they decided my son's life.
Yeah. Hey, Randy Roth. Thank you for climbing aboard with Lady Justice, Liberty Press, as well as Mr. Amazing.
Here's probably the people we need to contact right here. First Amendment scholars, Jane Bombeyer, Ashtut Bhagwat, Clay Carver, Alan Chen, Margot Kaminsky, Seth Kramer. We need to call these people actually. Scott Skinner Thompson, National Police Accountability Project, Cato Institute, Electronic Frontier Foundation, United States of America. The United States, the Electronic Frontier Foundation, United States of America. Wow. Anyways, we will try to incorporate this all. You know, we were over on 22nd and Dayton when they were investigating the shooting, guys.
Mm-hmm.
And they were just doing some talking to witnesses, I guess, or something. And for some reason, they didn't want to have us there.
Yeah. Even though we announced we were there as press, acting as press, they didn't like it. And, yeah. I was live that evening, So on my channel, it is there. I think I may have it, unlisted right now, that particular live.
So I'm gonna have it use all of the information that it gave me up here, guys, on the United States. I'm gonna have it use Houston v. Hill. I'm gonna have it use and Irizarry, like we talked about.
Mhm.
So where did it go now? Oh, okay, it's gotta be where I can draw from.
Did you wanna look at that email that,
Yeah.
Leslie?
I do, definitely do.
Let me get back over there. Right here it is.
Oh, this is cool. Crib sheet, huh?
Yeah.
Ransbury v. Hayes. Okay. Just seems like I'm getting slow feedback from the AI for some reason. I don't know. I'm paying for premium, but it's giving me a bunch of baloney. I guess it's just taking a while. Well, we're using a lot of AI power here. It's just taking a little bit, guys. Let's wait on it. I don't know if that is a lot of reading, because there may be something on that page particularly that she wanted us to look at all. The first one didn't seem to apply. The second one seems to have something to do with the seatbelt or something. I don't know, but
Well, let me look.
just need a little bit more help than that, I think. This chat GPT be making me mad right now. I never had a like, Gemini do this to me. Is this a real AI or am I on some Indian freaking scam bait AI site or something? What the heck? I've been watching those scam baiter videos on YouTube. They're so funny. They take these scammers and they look at them through their computer and it's just great. So what were these other ones though? I thought we had a couple more that were. A second ago. I think it was the ones in her email.
The ones in my email?
Yeah, the ones you were just looking at. Is this the same list?
Yeah.
Well, we'll have to narrow it down a little.
Okay.
What's the site? Can you message me the site that she gave you there, please? Is this just there's no links or
No, it's just what she's.
the copy paste?
Mhm.
Maybe a link to the site or something. I can have the AI look all through the whole site. I mean, it's a lot faster, is all I'm saying. It'll help a lot. So here's another draft motion, guys. We're gonna go with this one, I think. It's gonna include the VIA, it's gonna include the Houston v. Hill. Oh, I didn't mention Smith v. Cummins. Search the internet for information on Smith v. Cummins, Georgia. Extract anything that would be useful to our motion for dismissal in this case.
Turner v. Driver.
So here I've just asked it to provide the information about these new cases in the same formatting as in our previous query. So that way I will get it to come back looking the way I asked it to already with all those other. Thank you guys for helping us, man. We needed a lot of
Absolutely.
support on this, and some keyboard warriors helping us out. We go a long ways. Sure do appreciate each and every one of you. Boom, it just searched 7 sites on the internet. That's why I like conversational AI. I'm just sitting here and I'm chatting with it, and I may have some good stuff, and I may have some irregular thought patterns, and it just throws away. It draws from those irregular thought patterns, guys, to try to find out what I want. And then it makes it all make sense, and it gives it back to me in a way that I can actually share to somebody else instead of, me, Mr. Amazing.
Here's another one where journalists can be in unsecure places, right here,
Okay,
1985.
let's draw from this.
Okay.
Adding more to examine. Like this?
Mm-hmm.
Look at Cox Communications. Let's examine Cox Communications. Lower Georgia 173 Appeals Court, 1985. Journalists can be legally in public, uncensored. So I'll just ask it to look at these things, and it will draw everything out of there. I don't know how it does it, but oh, this is a good one. Click v Connect. Very good. Kanifi.
There's some really good case law here.
There sure is. Thank you.
Absolutely. Yeah, absolutely.
They'll probably dismiss this case now, guys. Plus, we were gonna ask for a bill of
Hopefully.
particulars, right? Bill of particulars.
Oh, and we also want them to, affidavit of truths.
That's right. We're gonna ask for an affidavit of truth too.
Absolutely. what they have is like a 24-second video, and on that 24-second video, only about 3.5 seconds is actually audio.
Yep, there's nothing on the video, guys, it's ridiculous.
Yeah. So this is a good case, I think, if you want to get your feet wet. There's no jail time being sought, which is good. So basically it'd be, what, a monetary, whatever, or possible, maybe some classes, I don't know. But there's not gonna be any jail time, so that's a good thing.
So yeah, it was unbelievable, guys. I was working on my custody case, and the other side's attorney actually contested my motion for continuance, and part of their contest for the motion for continuance was that I was acting in bad faith. And I thought, that's amazing. You know, here I am trying to do everything I can for this kid, pro se, without an attorney, and it was challenging, and it took longer, and they're gonna actually say that me, the father, is acting in bad faith. But these people this shouldn't even be happening. These people have no connection to my son.
No, they're non-family.
He's 7 years old. He lived with me for 3 of those years, and I was doing fine until the mother took him away, and now he's been left in the care of a non-familial custodian. I couldn't get pro bono help in the state of Mississippi because the law does require that the person receiving the pro bono help live in the community where they're receiving the pro bono help from. And since I live in Colorado, I need to have paid retainer for my attorney. There's laws around that too. They have to have a retainer. They can't work with you on that. And that's an ethics law. So I was really hands tied on the whole thing there. We are doing a crowd fundraising for this case, guys. We want to come up with 6 G's to get the Bulldog attorney. If you guys want to make donations to Lady J's Cash App or my own, it's $Amazing Audits. Put custody in the title line. Everything will go to the custody case.
That's right.
And I'll find an attorney that unbundles maybe, and we can get representation for cheaper if possible. Any leftover funds would then probably be used to just help raise my kid and stuff, and get us a fresh start.
Yeah.
Thank you, guys. Doing my best on that matter. Anyways, back to the defense of our obstruction and disturbing the peace charges in Aurora, Colorado. Here's our summons. This is a J summons, they call it. It has instructions for you to plead guilty, I think, on the back of this if you want to. Don't ever do that. That's probably not a good idea.
Guilty. Not good, not good.
Here, and we've got a few minutes left in this room. Let's go over the new motion for dismissal. Okay, guys, and as I'm looking at this, with your guys' help and the help of the conversational AI, so that just goes to point out how talking with one person is amazing, you know what I mean? And when you use AI, it kind of has talked to many people, and so it's got this worldly view of things. Look, it has come up with your guys' help, we not only have 4 reasons, but we have 7 reasons, legitimate reasons why the court should dismiss this case. All right, now let's go over them. All right, this is all regarding the First Amendment. If you're just now tuning in, me and Lady J were acting as paid members of the press, getting video on an assignment we received on Springer, a gig app from the internet. And while we were out, we contested that there should be some yellow tape. We criticized the police. We protested a little. Some of the neighbors complained, and in the long run, we did receive this ticket right here for obstructing and interfering and disturbing the peace. That's 2 charges.
Yeah.
Here goes our motion for dismissal. Defendant's motion to dismiss. Comes now the defendant in the above captioned matter by and through his above captioned manner pro se, this is gonna read. And hereby moves this court to dismiss the charges filed against him. In support of this motion, the defendant states the following. The First Amendment protection, Irizarry v. Yahia, 2022. Smith v. City of Cumming, 2000. Glick v. Knife, 2011. These cases affirm the right to film police activities in such public places as a protected First Amendment These cases affirm the right to film police activities in public as a protected First Amendment activity. The defendant was engaged in similar lawful activity documenting public servants in a public space which is constitutionally protected, everyone. Journalistic freedom. Cox Communications Incorporated versus Lowe, 1985. The court held that broadcasting information that is already a matter of the public record does not constitute an invasion of privacy, supporting the defendant's right to disseminate information about the public police activities. Absence of actual malice. New York Times Company v. Sullivan, 1964. The Supreme Court established that the freedom of speech is protected against defamation claims unless made with actual malice. This principle supports the broad protections afforded to speech about public concerns. Number 4, protection of parodic expression. Hustler Magazine Incorporated v. Falwell, 1988. The Supreme Court highlighted the First Amendment's protection of parody and satire, underscoring the wide berth given to expressive content, pertinent if the defendant's actions are claimed to be disruptive but are part of expressive conduct. 5. Legality of publishing lawfully obtained information. Florida Star v. BJF, 1989. This case protects the publication of lawfully obtained information significant to public interest, reinforcing the defendant's right to disseminate the information on public police activities. Protection number 6, protection against penalizing non-inciting speech. Cohen v. California, 1971. This ruling supports the defendant's right to verbal expression in public without the fear of prosecution, unless it is likely to incite imminent lawless action. Protection of unlawfully intercepted communications. Although not directly applicable, this case shows that the extent of First Amendment protections, even when the speech involves unlawfully intercepted communications, as long as the publisher did not participate in the interception and the matter is of public importance. So these all kind of uphold the importance of transparency and First Amendment activities, basically, freedom of press. Did we lose anything from the last one, do you feel like?
I don't think so.
What about, yeah, the factual background, the charges violate the First Amendment. We're gonna add these things in there.
It was a federal something I was looking at.
Let's check that out. Thank you, everybody.
Yes.
Also, let's try to keep in mind that it was the obstruction and disturbing the peace are the particular things that we need to look at.
Versus Chicago. Yeah, you got this, federal, this one right here. This F1.
Well, it's Houston, you know,
Mhm.
we drew from that one. Terminology, Chicago. Function of free speech is to invite dispute, inducing conditions of unrest, even stirring people to anger. Let's see. Terminology, Chicago. Hang on to those, make sure that you notate those, please. We're gonna incorporate them into our defense for sure. I think what we have here are Can't you use any of that case law to make a stronger argument? Here we go, I just love it. I paid for the premium chat GPT-4, guys, it's awesome. It's sitting there, I'm getting powerful, computing here. It's taking a minute to come up with all the details, it's thinking hard. It will go and read the internet for me, it'll look at pictures and stuff, it'll read PDFs, like it helps me a lot.
So it's worth it then, huh?
It is, it's worth it. It definitely is worth it, I would say. With its help, we're gonna be done with this motion to dismiss. It's gonna look professional. It's going to probably blow the opposition's mind that we're coming up with it. How are they doing this? They're getting help. Frankly, the thing's better than any public defender I've ever had in my life.
You mean public pretender?
Public pretenders, yeah.
Public
When you
pretender.
get abducted and kidnapped, and you need one of those public pretenders to help you.
Oh, it's thinking.
Mm-hmm. So we'll be done with this. It took us less than an hour, guys, I think. How long has this live stream been? 53 minutes. And we've got the motion done. So if a lawyer could definitely have done this in a much quicker amount of time. Don't let them BS you about how they're charging you by the hour, $60 an hour, $100, $200, $300 an hour, or whatever, guys. This is ridiculous, okay? Here, I'm half an idiot. I'm mostly illiterate. And I just came up with probably a far better motion for dismissal than any public pretender has ever produced.
And that's
College
fact.
educated professional.
Yeah.
Let's check it out. Would you guys like to hear the strengthened one now with everything all woven into it?
I sure would.
This will be the last one, and then we'll end the stream.
Okay.
We do have some more stuff to talk about. We have meeting coming up. We're gonna teach some people how to use conversational AI to write effective legal arguments or answers, responses to arguments.
Yeah.
Okay? First, let's go over this, guys. Boom. So right here, go back. I think this is where it was. Select all, we're gonna make it the same point type, everything. Make sure none of it's bold or nothing. We don't want it looking goofy.
Hey, we've got My Flock in the house
Hi, my flock.
and Northwoods Press.
Thanks for being here, everybody. Please go back and watch the beginning part of this video about pro se motions for dismissal. We received some charges while we were out doing our job, guys, our hobby, whatever you want to call it. I was actually on a paid assignment, so this was a job, in fact.
It was.
Here we go. We've refined it down pretty good, guys. We've used the factual background, the charges. We're talking about the charges. We have our arguments. There's that. And we've talked about insufficiency of evidence. Let's go over it. Let's read it. Motion to dismiss comes now. Defendant pro se and respectfully moves this court to dismiss the charges of disturbing the peace and obstructing brought against him. In support thereof, the defendant states the following. 1. Factual background. The defendant was lawfully present at the scene of a reported homicide in Aurora on Dayton Street while exercising First Amendment rights as a journalist / member of the public. The defendant interacted with officers of the Aurora Police Department investigating the incident. This interaction involved the defendant verbally protesting, questioning the officer's instructions regarding restrictions placed on being near the crime scene. The charges violate the First Amendment. The charges of obstructing and disturbing the peace violate the defendant's First Amendment rights of freedom of speech, freedom of the press, and freedom of assembly. As a journalist, the defendant has a well-established right to gather news, including observing and recording police activity in public spaces. The defendant's actions at the scene fall squarely within his right. The First Amendment protects the right to express opinions and question government officials, including police officers. The defendant's questioning protest officers' instructions constituted protected speech, freedom of assembly. The First Amendment protects the right to peaceably assemble in public. The defendant's presence at the scene, even if near a crime scene, is protected by this right. 2, our argument. Okay, the argument. So I think I need to put like an I up here instead of a 1. Or I need to just put like a 1 here. Argument. The charges violate the First Amendment. Okay, so wait, hold on now. Needs to be restructured a little bit better, guys. Here I have what I want right there, but we're basically contending that it was well within our rights, that the charges violate our First Amendment right, that these case laws that we talked about, Smith v. City of Cumming 2000, Glick v. Knife 2011, Cox Communications versus Lowe 1985, and these other things, Florida Star versus BJF, show that the First Amendment is upheld and it's widely protected. Okay, we're also going to attack the insufficiency of evidence. They didn't provide enough evidence in their discovery to show much of anything, actually. Guys, there was just a couple of police reports and a video that shows nothing. In conclusion, in light of the precedents set by Smith v. Cumming, Glick v. Knife, Cox Communications Incorporated below, coupled with it is evident that the charges against the defendant are fundamentally flawed and violate constitutional protections. The defendant therefore respectfully requests that this court dismiss the charges. The court lacks sufficient evidence. Hold on, we already went over that. To further go on about lacking sufficient evidence, even if the court finds the defendant's actions were not protected by the First Amendment, the charges lack sufficient evidence. There's no legal standard. The city must prove beyond a reasonable doubt that the defendant's conduct intentionally or recklessly caused alarm or inconvenience, engaged in fighting behavior, and or obstructed police. Mere verbal protest or disagreements with police officers, even if heated, do not rise to the level of obstruction and disturbing the peace. Insufficiency of evidence. Did we go over that already? The available discovery materials, including police reports and body camera footage, fail to demonstrate that the defendant's actions constituted disorderly conduct or disturbance of the peace. Now, it's not disorderly conduct, though. I keep saying that. It needs to be obstruction.
Yeah.
Conclusion. For the foregoing reasons, the defendant respectfully requests that this court dismiss the charges of disorderly conduct. It's not disorderly conduct, it's obstruction, obstructing and disturbing the peace. Brought against him. Respectfully submitted, Jamie Bates. So what do you guys think? Conversational AI for an hour. Couple of, one smart person and one dumbass. And we got a pretty nice motion for dismissal there, don't you think?
I think so.
Now, we're going to go out of the study room and we're going to email these motions for dismissal. We're going to refine it down a little bit. We appreciate you guys watching. That was a pretty good live stream we did there. How long did it go? 1 hour, 2 minutes. We sure appreciate each and every one of you guys for being here. Let's read some chats, a couple of chats, and then we will call it that.
Hey, Leslie Sullivan. Well done, Liberty, Team Liberty for prosperity. Love it. Fantastic, my flock.
We got Fuckface News, Car Thief News in the house.
Hey.
Joco, Kansas Cop Watch. Mitten State, it was a mistake, sorry. Mitten State Media. Army with Harmony 2024, Year of the Dragon. Thank you for being here. Appreciate your comment about the audio. Let's turn that down a little, please. Yeah. 5x5, Car Thief News. Lady Justice Liberty Press. Hey. On Board, Leslie Sullivan. Thank you for being here. And everybody tuning in. We appreciate each and every one of you. No Name Coder, I see you there. Northwoods Press, My Flock. And if we haven't mentioned your name already, it's not because we don't care. It's just because we didn't see your name in the chat or you didn't chime in. Please let us know from where you're watching from. Please let us know if there was a part of this video that helped you. I would like to know that I have done some effective education here today. And if you find conversational AI helpful and you watched my video and got a couple of tips, please leave a comment below. Appreciate that, guys.
Hey, we've got Toe for Life Chronicles in the house.
Hell yes. Toe for Life Chronicles. What up, man? How's the little one doing?
You guys make sure
Thank you,
you
Northwood Press.
give somebody you love a good squeeze today, a big hug. Hey, we've got
Randy Roth.
West Side Accountability.
We love our West Side Accountability. Everybody tune in, ring the bell over there at West Side Accountability. There's great live stream chats over there. What an awesome radio station or a vlog to be a part of, guys. All right, well,
Thank you one and all for climbing aboard and hanging out with Mr. Amazing from Amazing Audits and Lady J1A today.
love y'all. Boop, 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 wee, whoop.
Giddy up.